Speaker. It's a pleasure to follow the Right Honourable Member for Tottenham. Whilst I may differ with his analysis, there's never any doubt that he holds his views passionately and certainly supports his constituency and communities passionately, and has done so in the last several years that I've watched him in this House. It's also a pleasure, I think, the Prime Minister to talk about the real Queen's speech, as against the other one that we ran last week. And I will say about this one that it has enormous merits to it, particularly in the areas of growth. I'm particularly supportive, as he would be unsurprised to hear, of his proposals on bank reforms, competition law, enterprise law reform, including labour law reform. All of those he will be very happy to hear. But I'm afraid it goes downhill from here on in. Well, I'll make the whole minute. I'll make the whole minute by saying this: that the government can be proud of most of its record in the last couple of years on the issues of liberty and justice, which he knows I hold very dear. Certainly, its actions on identity cards, its actions on cutting down the amount of detention without charge, the misuse of stop and search, counter-terrorism stop and search, are all matters of pride for the government. But from here, I have a concern, or three concerns to be quite accurate. One of them is about a constitutional issue, one of them about state power, and one about justice. Let me start with the constitutional issue, the issue that the Right Honourable Member for Tottenham finished on, the issue of the House of Lords. One of the concerns that I have about the whole approach to the House of Lords is that we are arguing about the composition without worrying enough about the purpose. We haven't done enough to consider the purpose of the House of Lords. Now, there's a great deal of talk about the House as a revising and reforming chamber, but it has a much greater function than that. The House of Lords historically in this country has been a serious check on excessive executive power. It's been a check on the government of Margaret Thatcher when she had a very large majority, on the government of Tony Blair, on the government of Gordon Brown, and no doubt on this government as time goes on. It's very important in Britain that we have this check, because we are different in one respect from most other democracies. Without any separation of executive from legislature, the power of the executive in this House means this House is less good than it could be in terms of defending the rights of individuals when the executive impinges too much on it. We saw it very much in the last government. There were a great number of occasions when I'm sure many Labour members did not want to support some of its government's more illiberal actions, and this is why the House of Lords is incredibly important. And that of itself, I will give way to my right honourable friend.
I'm very grateful to my right honourable friend for giving way, and he's making a case from a Conservative point of view against reforming the makeup of the House of Lords. If the House of Lords has the distinguished record of preventing excessive use of executive power that my right honourable friend is suggesting, why does he think it was that Margaret Thatcher's first Lord Chancellor, Lord Hailsham, delivered a speech roughly 50 years ago in which he said that we didn't have sufficient checks and balances in our Constitution, and he characterised our Constitution as an elective dictatorship?
Well, I'm very grateful to my right honourable friend, because he goes right to the central point of this. And the House of Lords is not perfect. And there are many things that it's allowed to happen. And indeed, I'm in favour of reform of the House of Lords, but we've got to be very, very careful to get it right. Because if in our reform we do away with that check, or we weaken or mitigate that check to any great extent, it will never be returned. No government will ever bring back a restraint on its own powers. And one of the problems that arises from the fact that I think it was the Deputy Prime Minister actually who characterised what he saw as a preferred state of the House of Lords, is that it should more reflect the political composition of the House of Commons. Now, that is precisely what I would not want it to do. A House of Lords that exactly reflected the political composition of the House of Commons would actually be not very much of a check on the executive. And that is a really serious problem. So for my first concern is that we are very careful about how we do this. I do not think and I'll say this now to the government, I do not think a referendum of itself will solve the problem, because it's a subtle and difficult problem. It can be very hard to argue in public, but it's one which I think is very important. Is the Honourable Lady trying to intervene on me in a moment?
I thank my right honourable friend for giving way. Does he agree with me that, well, I agree with him that having a check on the government is the most important role of Parliament? And if you look at Parliament as a whole, does he agree with me that having an elected House of Lords would undermine the position of the elected members of this House, the House of Commons, and make it less likely that they will be able to hold the government to account in this House where the Prime Minister sits?
Well, I take her point. I think that there is a great problem in terms of just legislative gridlock if you gave too much legitimacy to the House of Lords. But I think the simple fact of the matter is, over the course of the last century, these houses have managed a balance which has been pretty effective without crippling government. But where we've arrived at now still needs reform, but it needs very, very careful reform. I give way to the honourable member.
I'm grateful to the right honourable gentleman. I agree with them that you have to look at two things hand in hand. One is the composition and the other is the function. And one of my criticisms of the draft bill, that I'm passionately in favour of an elected second chamber, is that clause 2, it seems to me, will not do the business of reinforcing the primacy of this chamber. You would have to have some kind of concordat agreed by both houses, written into the standing orders of both houses. But does he accept that the present situation is unsustainable? We already have far too many members down the other end of the House, and if no reform goes forward, there will be another 200. We'd be more than 1,000 members appointed, the vast majority of the time on a party whip appointed by party leaders. Surely this is unsustainable.
Well, I agree with that last point, but I say to him, don't let the best be the enemy of the good. I'm going to finish on this point with respect to the Lords, because I want to talk about two other significant issues of justice and freedom. But the test for me is to look back and see what would have happened in the last decade if we'd had whatever new reform we come up with. And in the last decade, as the Deputy Prime Minister will be only too conscious, the Lords have stopped the curbing of jury trials and a number of other measures, including extending detention without charge. That would not have happened if we'd had too politically similar a House of Lords. That's a simple test. And my test, when it comes down to it, when we actually look at this in some detail, I hope, in this House, will be whether or not it will achieve the same check on government. I'm going to stop on this because I want to move on. I'll give way if he wants later on this matter. The second issue is one of state power, and what has now become colloquially known as the Snoopers Charter. The proposal, and let me get the exact phrasing, the proposal in the Queen's speech, which says the government intends to bring forward measures to maintain the ability of law enforcement and intelligence agencies to access vital communications data under strict safeguards to protect the public, subject to scrutiny of draft clauses. And I take that last part to say that it's up for argument as to how it's going to happen, which is a good thing, because what is being proposed is the maintenance is very, very similar, I'm afraid, to what the previous Labour government came up with. Very similar, and I'll give way to the Deputy Prime Minister if he really wants to argue the point, but I don't recommend it because they've already consulted heavily with the ISPs and the producers, and they've talked to them about what they want to do. They want to create large databases, or require the companies to maintain large databases of contact information, of information where I've telephoned somebody, what the telephone call, who it's to, when it's done, where it's from, all of that data. It's it will lead to extremely large databases, which the state then wants to be able to access relatively freely. Now, I'm surprised, frankly, that this has come up under the government, because it was opposed by both parties in opposition and against, at least as I can see, the thrust of the coalition agreement, and certainly against the thrust of a comment made by my right honourable friend, the Prime Minister, when we were in opposition. He said then, faced with any problem, any crisis, given any excuse, Labour grasped for more information, pulling more and more people into the clutches of state data capture. And the government doesn't want to stop with the basic information. He goes on later to say, scare tactics to herd more disempowered citizens into the clutches of officialdom as people surrender more and more information about their lives, giving the state more and more power over their lives. if we want to stop the state controlling us, we must confront this surveillance state. Those were the Prime Minister's words in opposition. Now, we opposed these measures in opposition not just because they were illiberal, not just because they risked turning our entire country into a nation of suspects, but because we also believed they were ineffective. Nearly every one of the measures we opposed when I was his Shadow Home Secretary, we opposed because they thought they were ineffective. They would not work against terrorism. And that is also true of this measure. As a matter of interest, I went out and I took advice from experts in the area, and I asked them a very simple question. If you were a terrorist, how would you avoid this scrutiny? Well, I stopped them when they got to the fifth way of doing it, because it's pretty straightforward. If you really are a terrorist, everything from proxy servers through to using one-off mobile phones, this is very easy to avoid. If you're a criminal, it's very easy and quite cheap to avoid. But if you are an ordinary citizen, it is not easy and cheap to avoid. So we're going to create something which some government ministers have indicated will cost £2 billion, but the LSE has indicated will cost £12 billion. We're going to create something which will not be effective against terrorism, but which will be a general purpose, a general purpose surveillance on the entire nation. I give way to my honourable friend.
Stewart. Thank you, Mr. Speaker, and I thank my right honourable friend. But sometimes terrorists make a mistake. Yes. And it's for that reason, and if we save lives by actually having this information, that rather balances your argument, does it not?
Well, I'll come back to that I'll deal with it straight away, actually. It's very straightforward. The simple truth here is that when the House reacted understandably to the events of 2001, to 9/11, and the preceding terrorist events for that matter, but it reacted to the horrific events of 9/11 and brought in, and the USS Cole and the East African embassy bombings, and brought in a couple of measures, the Counter-Terrorism Act in 2001 and the prior act of RIPA in 2000. It did a number of things, and one thing it did was took away a large amount of what was the previous protections. Prior to RIPA, what used to happen is that the agencies would approach British Telecom, Cable and Wireless or whatever, and ask them for this data. And it was handed over voluntarily, sometimes, not always, sometimes. And the companies themselves exercised some responsibility. In about 2/3 of cases, the agencies got warrants. And, of course, then it had to be handed over. And the issue here is whether or not these not the only issue, but the central, main issue, is whether or not these databases are available to the agencies of the state without a warrant. Yep. They currently are available without a warrant. I'll give way 1 second. They're currently available without a warrant. If we want to make this acceptable in a civilised, liberal state, we should have warrants first. I'll give way. Yeah.
I'm grateful to the honourable gentleman for giving way. And speaking as a Liberal Democrat, but also as the MP for Cheltenham, can I ask him if he would agree that it should be possible to strike a perfectly good balance between the absolute need to protect civil liberties and traditional British freedoms, but also to apply the principles behind that existing legislation that he talks about to new and fast-developing technologies to prevent our security services from actually falling behind?
Yeah, of course. I mean, I do think, frankly, it's a little bit of a red herring to talk about falling behind. The security services today can collect more data by several orders of magnitude than they could when I first came into this House, just because technology actually allows that too. In 1987, pretty much you had to have a BT engineer go in and plug in your bug in the local exchange. You don't do that now. You can do it almost from my office by software. So, and you can do it for all of you at once. I can listen to all of you at once. I have to tell you, your conversations are too boring to bother with. But the simple truth is that he is of course right. He is of course right. There is a balance to be struck here. Nobody's been foolish enough to suggest that I favour helping terrorists, or favour making it easier for them, or favour making it harder for our own agencies. But we must do that under judicial control. We must return to the prior warrant process that applied before RIPA for these systems to work. I'm just about finishing this bit. I will return to the prior warrant process because that will actually ensure that what has happened dozens of times in the last decade with all of the new powers handed out, namely that they have been overused to an enormous extent, we must stop that happening with this. If we don't, the public reaction will be one of outrage. Because this isn't something that affects just a few people. This will affect tens of millions of people, and they will not take it very quietly. My last point is a justice point. And unlike the issue of the Snoopers Charter, which will create a tsunami of reaction as it goes through the House, I'm quite confident of that. We already have 137,000 signatories on the online petition on it. This issue is not like that. This issue is the issue of secret courts is what I'm talking about, is an issue which affects tens, maybe hundreds of people. But it brings against those tens or hundreds of people a serious injustice. And I'm afraid I take the view, very unfashionable in modern politics with too many polls and too many focus groups, that an injustice against one is an injustice against all. And what is proposed in the secret court proposals is undoubtedly an injustice. And I say that with complete confidence. And the reason I say that with complete confidence is a rather obscure one. This is a secret court procedure, and we of course already have secret court procedures. They're called SIAC courts, Special Immigration Appeal Courts, and they have existed since 1997 when Labour introduced them to deal with people who they felt they couldn't deal with in open court. And of course, nobody in this House has ever been in one. Nobody has ever seen one in operation. No one actually knows how they work. And I include in that no one all the ministers. All the ministers in this government and all the ministers in the previous government. There is one group of people alone who understand how these courts work. They're called special advocates. There are 69 of them. Of them, 32 have had detailed exposure to the closed material procedure that is being proposed. Now, what the closed material procedure involves is the executive, a minister, being able to say to a court, this information can only be heard in very close camera, not in the court as a whole in secret, but you, O judge, the prosecutor, the government side in the argument, and the other side in the argument, you and the government side of the argument can hear it, and a special advocate, a lawyer who cannot talk to the defendant or the litigant, whoever it might be in this case, he cannot talk to them. Only he can. In 1 second. Only he can challenge this. I give way. Yeah.
I'm grateful. We had a system of special advocates in courts in Northern Ireland for a very long time. Numbers of members of my chambers were special advocates in such circumstances, and I don't recall my right honourable friend, when we were in government, ever complaining about the procedures that we had to use in Northern Ireland, given the very particular circumstances in Northern Ireland.
Well, I'm sorry to correct his memory, but I did. And I actually did appear in a diplomat court as well, so I know exactly how they work as a witness in this. But the simple truth here is not my view. The simple truth is, what is the view of the special advocates, those 32 special advocates who've had this experience? Virtually all of them signed up to a document which challenged the government's green paper and challenged it in quite robust terms. If I can find the document, in quite robust terms. What they said was as follows. Closed material procedures represent a departure both from the principle of natural justice and from the principle of open justice. They may leave a litigant having little clear idea of the case deployed against him, and ultimately they may prevent some litigants from knowing they have won or lost. Furthermore, and crucially, because the special advocate appointed on his behalf is unable to take instruction in relation to that case, they may leave the special advocate with little realistic opportunity of responding effectively to that case. They also systematically exclude public, press and parliamentary scrutiny of parts of our justice system. They go on to say, Our experience of special advocates involved in statutory and non-statutory closed material procedures leaves us in no doubt that closed material procedures are inherently unfair. They do not, underlined, they do not work effectively, nor do they deliver procedural fairness. The fact that such procedures may be operated so as to meet the minimum standards required by Article 6 of the ECHR, with such modification as required by the court so as to reduce that inherent unfairness, does not and cannot make them objectively fair. That's the view of the only people who understand this system. The only people who understand this system. So I'm saying to the House today that this measure, this secret courts measure, is being held up as a proposal to improve our security. It undermines our justice system, it corrodes our justice system, and it does not improve our security system, because the other thing pointed out by special advocates is that the PII system as it now stands, again not properly understood by ministers, works perfectly well, much better than what is proposed. Indeed, one of them has pointed out that this proposal is actually less good than that available to the terrorist suspects in Guantanamo Bay. That's how poor this procedure is. And in fact, there are many other procedures abroad which would work better than this. So sadly, this is not a measure which I will be supporting in the coming months. I say this to the government. They came in with a very grand, important, liberal, small L and big L tradition to hold up. A tradition that supported both freedom and justice in this country. These two measures, put the Lords to one side, that's a matter for argument, but these two measures will, if we're not very careful, undermine that tradition, undermine our reputation in this, and do nothing to improve the protection of Britain against terrorism, just the reverse, make it worse.